Good evening. This side, Rahul Magan here. Apparently speaking, the law is divided into two parts. Number one, the criminal jurisdiction. Number two is the civil jurisdiction. I strongly believe that both jurisdictions are equally competent and complex in nature. On the contrary, my personal interest is always in the criminal jurisdiction. Thanks to EOW, Economic Offences Wing, which includes Prevention of Money Laundering, Insolvency and Bankruptcy Code, Foreign Exchange Management Act, Foreign Contribution Regulation Act, and variety of such acts. But having said that, my interest in civil jurisdiction is definitely not less. But I really love the Prevention of Money Laundering Act, and God willing, would try to be a lawyer in a Prevention of Money Laundering Act, not only in India, but across. Now, today, I would be talking about Chapter 29 of CrPC. Now, this is a Criminal Procedure Code, the bare act of the Criminal Procedure Code. It is not that I do not have the commentary, but at least for this video, I do not need any commentary. Ladies and gentlemen, on a technical note, I need to appreciate the framers of CrPC. Now, when I'm using the word CrPC, I'm talking about the old CrPC, because the new CrPC is coming effective 1st July 2024. God willing, in the month of June, we should start making the videos about the new CrPC, but for the time being, we are making videos on the existing laws. Chapter 29, which is titled as Appeals in CrPC, is one of the finest I would be into. But having said that, all sections of CrPC are relatively or equal importance. In this, I would be talking about three top sections. God willing, if the time permits, then we would have more deliberations in the upcoming video. Henceforth, I title this video as Part 1. Part 2 would be covering as the time permits. Number 1 is 374. Section 374, which is appeal from conviction. Now, in English, the conviction means when the relevant charges are framed against you and then you are convicted, some form of or some strong form of evidence like documentary evidence, oral evidence, witness testimony, deposition, probably some CCTV footage, maybe some surveillance camera footage, some phone recording, and XYZ, which comes against you, which proves that, and not to mention the forensic evidences in case of murder trials and so on and so forth. So 374 is about appeal from conviction. But ladies and gentlemen, please remember, when I'm using section 374, appeal from conviction, then who is raising that appeal is the accused himself, who is convicted in XYZ charges. Now, appeal from conviction. Now, 377 is relatively on a different note when it is appeal by the state against the sentence. When state is filing an appeal in the appellate court against the sentence and the ground is inadequacy. So let's assume that there are some charges which are framed, say XYZ, and the state feels that the minimum punishment should be 7 years, but that relevant person got a little lesser, which is 2 years. And the state is going against that conviction, and state is saying that no, it should not be 2 years, considering the gravity of the crime, considering the insensitive attitude of the accused, our society, and many other factors which states needs to put forward on the table. So this is appeal from against the sentence, but this is by the state. This is not by the accused, this is by the state. Now, maybe as the video progress or in our upcoming parts, I would be referring to PP rather than using a word state. But if I see the Bayer Act, then Bayer Act using a word state government, but in law we are used to using a word state or PP. Then I'm using a word 378, and that's also very important, which is called appeal in case of acquittal. Now, acquittal could be for many reasons, maybe weak evidence in nature, maybe fake evidences, maybe implication. Although there is a wide difference between acquittal and discharge, and let it be very honest, our CrPC is having enough provision, example 239, whereby accused can file a discharge petition saying that he is fakely implicated by XYZ person in XYZ case. He has nothing to do this with the material on record, the evidence on record, the government's on record is not confirming that he done with this, he is fakely implicated. So it means, which is the discharge application under 239. Appeal in case of acquittal. Now, this could either be done on the order by the district magistrate, or it could be done on the order of state, or it could be done by the central government himself in case the acquittal is done or the case belongs to any of the central act. Then the central government or the Delhi Special Police Establishment Act is also covered, part and parcel of this. 381 is relatively very important. It speaks about the appeal to the Court of Session, and 382, which is petition of appeal. Now, in the part 2, I would definitely try to cover 386, read with 389, but I would give a small glimpse of 389 in the part 4 or part 3 of the video. But 389, section 389 is very important because it's cover bail after conviction. Like once you are convicted, then you are asking for a bail from the higher courts, then you are fakely implicated, the material is not on the record, the evidence, and so on and so forth. So let's initiate our discussion with 374. But before that, let me tell you a small difference between two very important terms. When you are convicted on grounds of the charges which are framed against you, or probably any alteration or addition in the charges which are done by the court, which is under 216, then if it is done by Honorable Metropolitan Magistrate, then you can definitely appeal to the Court of Session, or you can directly appeal to the High Court. You can also go ahead with 136, which is special leave petition under, to Honorable Supreme Court of India. But having said that, Honorable Supreme Court of India having guidelines that the steps, example, you go to the high courts, first apply to the High Court. There are various guidelines in place, so we should be reading this before filing 136 special leave petition, like in what cases special leave petition is applicable, in one case special leave petition is not applicable, and so on and so forth. Now, we need to understand that 374 is about appeal from conviction. It means you are convicted. Now, any person, say X for our discussion, any person convicted on a trial held by the High Court in its extraordinary original criminal jurisprudence, High Court having the jurisprudence for criminal, jurisprudence for civil, and original side jurisprudence, may appeal to the Supreme Court. Definitely, if you are convicted from the High Court, you can definitely appeal to the Supreme Court of India. Now, here you may take the certificate, the fitness certificate from High Court, and then you can file an appeal. Else, you can go ahead with 136, which is special leave petition under Article 136 with Honorable Supreme Court of India. Subsection 2 is relatively very important. Any person, say X, convicted on a trial held by session judge or additional session judge ASJ, or on a trial held by any court in which the sentence of imprisonment for more than 7 years has been passed him or against any other person or against any other person convicted at the same trial, may appeal to High Court. Subsection 3 is very important. Save as otherwise provided in subsection 2, convict on a trial held by MM or ASJ or metropolitan magistrate or magistrate of first class or second class, sentenced under section 325, in respect to whom any order or a sentence has been made under 360. Now, ladies and gentlemen, please note that in section 374, the very important thing is appeal from conviction. I repeat, appeal from conviction. And who is filing this appeal? The person who would be filing this appeal is none other than the accused. If you are convicted in the court of Honorable MM, you would be filing, technically you should be filing to Court of Session, followed by the High Courts, and then to Honorable Supreme Court of India. But the final call you have to take. Subsection 4 is a time bound, which means when an appeal has been filed against the sentence passed under 376, 376A, AB, B, C, D, DA, DB, and E of the Indian Penal Code, the appeal shall be disposed of within a period of 6 months from the date of filing of such appeal. It means the legislator made this a time-bound exercise, which means if you are filing against conviction, and suppose this conviction is coming on ground of 376 and allied, which is definitely one of the gruesome, I would say, acts done by anybody, then the appeal to be disposed in 6 months, it's a time bound. So appeal from conviction 374. Before we move further, remember who is filing that appeal? Accused is filing the appeal. But 377 is on the other side of the coin, which is appeal to be filed by state against the sentence on ground of inadequacy. So state feels that, suppose in any offense the charges are framed XYZ, and the state feel that the minimum sentence should be of 7 years, but the court granted 2 years sentence. It is inadequate considering the crime which is committed, the moral impact on the society, the lessons to the other, and so on and so forth. They can file an appeal, which is 377. Now 377 saying, save as otherwise provided in the subsection 2, the state may, in the case of conviction on a trial held by any court other than the High Court, may direct public prosecutor, shortly known as PP, we generally use the word PP, to present an appeal against the sentence on grounds of inadequacy. The Court of Session, if the sentence is passed by a magistrate, or High Court if it is passed by any other court. But what would if it is passed under a special act or a central act? And here it is subsection 2. If the such conviction is in the case in which the offence has been investigated by Delhi Special Police Establishment DSPE, constituted under Delhi Special Police Establishment Act 1946, or by any other agency empowered to make investigation into offence under any central act, then even the central government can ask or direct the public prosecutor to present an appeal on the ground of inadequacy. So please take a note that if it is done by the then you go to ASJ, Court of Sessions. Else, if it is done by any other court, then you go to High Court. And remember, if it is DSP, Delhi Special Police Establishment Act, or any other investigating agency empowered under this act or the central acts, the central government may direct the PP to file an appeal against the sentence on ground of inadequacy. Please take a note of that. Again, the same thing is there which we are having in 374. God forbid if any appeal is filed when it covers 376 or the allied, then the period, the appeal supposed to be settled, whether it is by the accused himself or it is by the state. Now this is 6 months, which is said in the legislator. I repeat, which is 6 months, which is said in the legislator. So till now, we are done with two most important pillars as far as the appeal chapter is concerned. Number one, which is section 374, which means appeal against conviction. And I repeat that who is doing that appeal? Accused himself or herself is doing that appeal. Like the heading said, appeal against conviction. On the contrary, we are having section 377 in the same chapter, appeals, whereby the appeal is not made by accused, rather it is made by the opposite party in the criminal trial, which is state. We shortly refer this as a PP. The state is doing the appeal. So before I move forward to this, let me first remind you that 374, it is appeal from convictions. On the contrary, 377, it is by the state. Please further note that when we do the 377 appeal, in that sense, the state is doing the appeal on the ground of inadequacy. So state may feel that the adequate sentence should be 5 years, but that relevant person got 1 year, and state may be having, the prima facie evidences, the kind of gruesome act done by the accused. So based upon that, state is filing an appeal. Most importantly, we need to understand in 377, we also include Delhi Special Police Establishment and also the Central Act, which means the central government can also ask the PP to file an appeal on ground of inadequacy. So please do take a note of that. Now coming to a very important, which is appeal in case of acquittal. Now, previously 377 is appeal on the ground of inadequacy. Like just a hypothetical example I took, the punishment should be of 5 years, but he got 1 year, and state is going ahead for an appeal under this chapter, whereby state is saying, considering this XYZ and the prima facie evidence, the sentence should be of maximum, which is 5 years. Just a hypothetical example. On the contrary, 378 is relatively on the opposite side, which means appeal in case of acquittal. Now, acquittal and discharge, both in a layman language, looks same, but technically speaking, from a parlance of the law, the acquittal and discharge are completely different. But in this video, I'm not talking about the difference between acquittal and discharge. Probably in the later videos, when we're talking about the discharge petitions and 239, their approval, their rejections, and the appeal on discharge petitions and so on and so forth, we'll speak about that. Now, coming back to 378, the first subsection is saying, save as otherwise provided in subsection 2, and subject to the provisions of 3 and 5. Now, Part A, the district magistrate in any case direct the public prosecutor to present an appeal to the court of session from an order of acquittal passed by the magistrate in respect of cognizable and non-bailable offence. Now, the district magistrate holds the power to order public prosecutor state to file an appeal against acquittal in court of session. Now, if an appeal is filing in court of session, it means the acquittal is done by the trial court, MM. On the contrary, Part B, the state government may in any case, now here it is state. Now, when we are using a state, we generally means Directorate of Prosecution. The state may in any case direct the public prosecutor to present an appeal to the High Court from an original and appellate order of an acquittal passed by the court other than the High Court. Now, like I said, that even if a trial court, Honorable MM Magistrate is passing an order, you can challenge that directly in the High Court under 226, 227 and various sections. That depends what kind of order has been passed. You can also go ahead with the revision petition, which falls under 397, read with 398, 399, 400, and 401. And we should understand complete of 401, because here the interpretation which is made by Supreme Court is very, very excellent interpretation. And more importantly, Supreme Court also interpreted 397, the various pros and cons, the responsibilities and duties of 397 in Katinoff judgment, and I thank you to Supreme Court for that. Now, Part B, the state government in any case direct the public prosecutor to present an appeal to the High Court from an original or the appellate order of an acquittal passed by any court other than the High Court. So it means maybe the acquittal is done by the court of session where the cases are triable in court of session. It may possible the case was there at the Honorable MM Court. He got the trial, he got the acquittal after trial. Later, the state appealed to court of session. Then court of session also upheld that. Now state is planning to appeal to High Court for that. Subsection 2. If any such order of acquittal is passed in any case in which the offence has been investigated by Delhi Special Police Establishment, this is the same thing, and the central acts, then the central government can also direct the public prosecutor to present an appeal to the Court of Session from an order of acquittal passed by a magistrate of with respect to cognizable and non-bailable offence. Remember, the bail under non-bailable offence fall CrPC 437. It is wise to read CrPC 439 also with 437. Part B, to the High Court from an original or the appellate order of an acquittal passed by any court other than the High Court. Now here the point is that whether it is 377, which is, appeal against the sentence on the ground of inadequacy, or whether it is 378, appeal on grounds of acquittal. Now, when it comes to the Central Act or DSP, Delhi Special Police Establishment Act, the central government holds the power to direct the public prosecutor to file an appeal, whether it is 377 or it is 378. Please note, I am talking about old CrPC. Now, as I earlier said, that new CrPC is coming effective 1st July 2024. Let him come and then we'll interpret how CrPC and let the things come on the table. But this is all about new CrPC. Ladies and gentlemen, I once again repeat 374, 377 and 378. (378) when you are filing an appeal in case of acquittal. Now, this is a very important section because it covers the complaint also. Ladies and gentlemen, on a very layman note, I say on a very layman note, that cases in India are broadly, when I say cases means criminal, cases in India are broadly categorized into two parts. Number one, when they are filing as a private complaint and when there is a police report. I don't think I need to further repeat what is police report 154, 173, 173.2, 173.6, 154, 173.8, and so on and so forth. Now, having said that, if I go with the subsection 4 of section 378, which is appeal against acquittal, then the beauty is that it also covers the complaint cases, which means that if such an order of acquittal is passed in any case instituted upon a complaint and the High Court on an application made it by the complainant in his behalf grants special leave to appeal from the order of the acquittal, the complainant may present such appeal to the High Court. So basically, if any complaint case has been filed, sometimes it is possible that on a complaint case there is a police report also. Now, there is a complaint case and there is a police report also which is going on. Now, I'll just take a hold here and let me take you to one of the sections which speaks about that. Just hold for, yeah. which is section 210 of CrPC, which says that procedure to be followed when there is a complaint case and the police investigation in respect to the same offense, which means when in a case instituted otherwise than a police report, herein referred to as a complaint case, it made it to appear to the magistrate during the course of inquiry or trial held by him that an investigation by the police is in process in relation to the offense which is a subject matter of an inquiry or a trial held by him. The magistrates shall stay the proceedings of such inquiry or trial and call for a report on that matter from the police officer conducting that investigation. Subsection 1 of section 210. So I once again repeat that broadly the cases are divided into two parts in a very layman parlance, which is on a complaint cases and on a police report. But ladies and gentlemen, do remember that section 210 of CrPC is having an interplay when there is a complaint case and at the same time police is also doing a parallel investigation, or a kind of a due diligence or an investigation in that regards. Ladies and gentlemen, 210 is having a perfect interplay as far as 378 is concerned. What would if there is a complaint case and on that complaint case there is a police investigation also, and the magistrate put a stay on the complaint case and wait for the police investigation and police report in a layman parlance. And when he cited the police report, he cited that no offense has been made out. The prima facie there is no evidence, or even if there are some allegations or averments in the complaint, then they are omnibus, reckless in nature, and the complaint stands dubious and discredited. Please take a note that today itself I went through one of the finest, judgments of Honorable Supreme Court of India, whereby they cited how a complaint, the fake, frivolous, vexatious complaints to be dealt with in the trial court. Now, similarly, 378 subsection 4 is having an interplay with 210. Now, subsection 5, no application under subsection 4 for the grant of special leave to appeal from an order of acquittal shall be entertained by the High Court after the expiry of 6 months. If this is a complaint, if the complainant is a public servant, so in case of the public servant, the limitation granted is 6 months, precisely 180 days. And in case of other, it is 60 days. So there is a limitation period. But I know that Act is not talking about condonment, but in my personal opinion, if there is a genuine reason, then one can apply for condonment. And of course, the final call definitely is in the hands of Honorable High Court. We are no one to take a final call. And then subsection 6, if the application, if in any case, the application under subsection 4, which means the complaint case, for the grant of the special leave to appeal from an order of acquittal is refused, no appeal from the order of acquittal shall lie in subsection 1 or subsection 2. Now, subsection 1 talks about the district magistrate and the state, and subsection 2 talks about Delhi Special Police Establishment and the Central Acts. So, having said that, we are having three things. Number one, 374, appeal against conviction. Who is making that appeal? Accused himself or herself is making that appeal. Point number 2, 377, when state is making an appeal on sentence on grounds of inadequacy. Now, just hypothetically, state feels that the adequate sentence should be 5 years, but that relevant person XYZ say got 1 year sentence and prima facie the evidences and everything, it should be 5 years. 378, appeal against acquittal. Now, here do remember that subsection 4, the complaint cases are also covered, and remember CrPC 210 is very important because here there is an interplay of complete complaint case and also of the police report. So, ladies and gentlemen, like I said, this chapter, which is titled as Appeal, is a very, very important chapter. Of course, we are yet to cover one of the finest, which is 386. Probably we would be covering in the next version. But having said that, 374, 377, 378, and not to mention the interplay of 378 subsection 4 with 210 CrPC is relatively very, very important. I once again repeat that when we study the criminal law, then it is always a wise thing to download the judgments of Honorable Supreme Court of India and say and see the interpretation by Honorable Supreme Court on the relevant section, that how Honorable Supreme Court interpreted that, how Honorable Court created an interplay between various sections, and on what grounds, what is a ratio, what ground Supreme Court created pertaining to that.